Hello students, today we would like to take a look at the Muslim law of inheritance. Now at the very outset we must remember that the Muslim law of inheritance is fundamentally different from the Hindu law of succession. Now the Muslim law of inheritance is basically guided by the pre-Islamic customary law principles and also the Quran and the Hadith tradition of law. Now Prophet Muhammad brought in certain reforms in the pre-Islamic customary law and it finds its resonance in the Muslim law of inheritance. Number one, the females were completely excluded in the pre-Islamic customary law scenario. Now, Prophet changed this scenario. He said that females would also should have rights, and he brought in categories of husband, wife, parents, cognates, as agnates were only preferred before that, cognates to the inheritance aspect of Muslim law. Inheritance simply means something which we inherit from ancestor. A person inherits from his ancestor, that is takes after the death of that his ancestor. And in simple words, it could be son taking from his father, let's say. Okay. So now in Muslim law, basically the aspect of inheritance is understood only after the death of a person. So till the time a person is not dead, the aspect of inheritance and the question of opening up of inheritance doesn't come up. It doesn't open up. So only after that a man dies that the question of inheritance comes up and inheritance opens up basically. Then you must also remember that before we understand that who are the persons who get the shares, there are three categories basically. The categories of sharers, there are categories of residuaries, and there is a category of distant kindred. So these are the three categories which we will deal with in our upcoming meetings. But then first of all, we need to understand what is heritable property. Now heritable property is something which remains after satisfying certain items in Muslim law. For example, it is required from the estate of a dead man that his debts should be satisfied. The funeral expenses are taken out from the estate of a dead person. If there is any legal cost which has to be incurred with regard to the letters of probate and administration of the court, so that charges has to be taken out. Also, for example, there are sometimes some instances may come up that just before the death of the person was being taken care of by an attendant or someone who used to take close care of him. So that 3 months wages of that person would also be deducted from the composite heritable property of the dead man. And only after removing all these obligations, whatever is left will be shared with the categories of sharers, residuaries, and distant kindred. So that which we will be taking up in detail. Then also you must remember that Islamic law is how the Sunnis and the Shias have observed the inheritance aspects of Islamic law. Sunnis have by and large adhered to the reforms which have been proposed by Prophet Muhammad, and they do acknowledge some of the pre-customary law, but they by and large uphold the Quran, the dictates of the Quran. Whereas in the Shias, they experiment a bit more. They try to fuse the pre-Islamic customary laws with the modern notions of Islamic law, and then they have a completely altered set of circumstances. So we would have a brief introduction to how the property is inherited in both the scenarios with some case examples as well. So please understand one thing: females were completely excluded in the pre-Islamic customary law scenario, and they got right during the Prophet. However, still, what a female got, for example, female would still gets only half of what the corresponding male relation is going to get. For example, I am just going to read this one paragraph for your benefit, and this will make it clear to you how the Quran expects that the property and the estate should be divided among the claimants. Now, the Quran says, God hath thus commanded you concerning your children. A male shall have as much as the share of two females, but if they be females only and above two in number, they shall have 2/3 part of what the deceased shall leave, what a dead person leaves. So from that they will have 2/3 part. This is what the Quran says. And if there be but one, she shall have the half, and the parents of the deceased shall have each of them a sixth part of what he shall leave, if he have a child. But if he have no child and his parents be his heirs, then his mother shall have the third part, and if he have brethren, his mother shall have a sixth part after satisfying the legacies. So whatever contemplation in the law is there, you can see that how Quran does it. Quran is saying that suppose if there is only one son, then so much is to be the share. If it is saying, let's say there is no son, there are two daughters, then what is to be the share? Let's say there are parents, then also what is to be the share? So overall, what is coming out of from this discussion is this, that the share of each particular claimant is fixed even before the death of the propositus, or you can spell it as propositus, propositus. So propositus is the person who dies and he leaves behind heritable property, which has to then go further to the claimants. So now there is also some important rules which you have to keep in mind while dealing with inheritance law of Muslims. The general rule is that the inheritance for the first time opens only after the death of the person, and a right by birth, as it is known in Hindu law, is something which is unknown in Muslim law. In Muslim law, we do not have a concept of joint family as such. We do not have a concept of joint family. The shares are fixed, and also there is no presumptive or heir apparent right. For example, a person says that, look, tomorrow my father is going to die, so I will inherit this. And if the father wants to gift away the property to someone, then this son objects that, look, you cannot transfer it. However, this is not the case in Muslim law. So what is the case? Muslim law simply says that inheritance opens only upon the death of the propositus. So the son cannot really fight if the father gifts it away. Separately, there is an aspect of will also, and there is an Islamic law of will also there, which dictates that a person who has a property may will only up to certain extent, and under what circumstances he can will the property away. So that is separate thing which we will take care of. But the general rule of inheritance is this, that it only opens up after the death of the person, which you have to keep in mind. Now there is an aspect of per stirps and per capita under Islamic law. Now, what is per capita? Now, for example, when we talk about the distribution of property, there are branches within the family. For example, let's take an example. There is one person, ex-Muslim, and he has two sons. Okay, one son has predeceased him, and there is one son from his son. It means one grandson is there, and the son is dead for this ex-person, right? Then now he has another son, but from the other son he has two sons. So in total this person has three grandsons. Now how would it go in case of per stirps? STIRPES, stirps, per stirps distribution. How it would take place? It would take place in the sense that we are talking about the branch of the family. So different branches will be taking. So one particular grandson will be taking one half, and the rest other two grandsons of the different son, who are the children of different son, the other son, will also take half. So this is going per stirps as per the branch. However, if we talk about per capita, then it would be that all three grandsons who are now existing, they will take 1/3, 1/3, 1/3. So this is the type of division which is contemplated under Islamic law, and this is what we would be looking at. There are certain rules of exclusion and inclusion which we have to keep in mind. But then before that, I would just like to quote one important case here. Like in the case of Mukhtar Ahmad versus Mahmoodi Khatun, the Jharkhand High Court has held that under Muslim law there is no concept of jointness or nucleus of any concept that property is purchased from the joint stock. So there is no concept of a jointness in the property as you understand that in the Hindu law of succession. So all properties which are exclusively purchased by sale deed by the female in her own name would be divided between her children. So with these points, we close our discussion for the day. However, we would like to look at the specific rules of inclusion, specific rules of exclusion with particular case studies. We would look at what is the principle of rule of primogeniture, what is the rule of representations, and what are the different rules which guide it. So this will be those aspects will be made clear, and then we will progress further. So once again, summing up what we have learned today, we have tried to see that in the pre-Islamic customary law, females were completely excluded from inheriting any sort of property. However, after the coming of Prophet, certain reforms were introduced in the Islamic law, and he brought in certain newer categories of persons who were to be claimants, or who had a share, who used to have fixed share as per the dictates of the Quran in the estate of a dead man. Then we have also got to know that inheritance under Islamic law only opens up after the death of the proprietress. Proprietress is the person who dies and leaves behind an estate, which may be then further divided as per the inheritance law of the Islam. Now there are certain things which, or you may say that certain items which are deducted from the property, and whatever is left after making those deductions is known as the heritable property. And then this heritable property goes to sharers, distant kindred, and to residuaries. And what are the nature of those particular relations, that will also see in the upcoming discussions. So with this, friends, I say close this session interaction for now. Please start reading some general concepts on the inheritance law, and we will take our discussion further. Thank you so much for joining.